members of the legal fraternity are taking issue with what they say is a breach of dignity in the aftermath of Judge Ruth Lawrence's death. The Jamaican Bar Association says it's deeply troubled by the apparent non-observance of the Data Protection Act, which enshrines the right to privacy in death. Amoy Harriet reports.
Every intimate detail of Judge Ruth Lawrence's final hours was laid bare, including an hour-by-hour account of the events leading to her death. The release of such sensitive information has sparked outrage within the legal fraternity, with many calling it a serious breach of privacy under the Data Protection Act. Notably, under the Jamaica Data Protection Act 2020, personal data of deceased individuals is protected for up to 30 years after their death. In a press release on Thursday, the Jamaica Bar Association said they're deeply troubled by the apparent non-observance of the Data Protection Act, which enshrines the right to privacy and the dignity of the individual, even in death. The association went further to say the act affirms that personal data must be handled with care, respect, and lawful purpose. It said the dissemination of intimate and distressing information without appropriate safeguards or justification undermines the solemnity of death, the humanity of the deceased, and those who are left to mourn her passing. The Bar Association says it condemns this breach in the strongest terms.
The indignity hits harder because here it is that she is someone who, everything that you read about her, she has given dedicated service to the public and to her community, and there is no basis on which she should have been treated in that manner.
Georgia Gibson Henlin is a fellow of Information Privacy and Managing Director of Privacy and Legal Management Consultants Limited.
And from a legal perspective, I am not sure of the source of the information, but it does appear, in terms of what I saw, it appears to be well ordered, well written, and it included information that is protected from disclosure under the Data Protection Act, because her name was there, that of her husband was there, her address was there, the whole health situation, which is very sensitive personal information under the Act.
Mrs. Henlin contends that the public, in particular media entities, must do better to balance citizens' rights to know and upholding the law.
Well, the duty to protect privacy is first. And so in terms of putting the information out there or communicating the information to the public, one has to first have regard to the fact of the law. And is it necessary to disclose that level of detail in order to communicate the story? It seems to me that we revel in the excitement of gore these days.
She argues the Data Protection Act needs strengthening.
Here it is that something has happened, and we'll have to basically search for ordinary remedies in order to deal with something as egregious as this. So the law needs to be fully brought into effect so that when there's a breach, the full consequences can be brought to bear. Because if ever there was a case that cries out for an act of deterrence, it is this one.
Amoy Harriet reporting for CVM News.